Good morning, and thanks for joining us for Washington's New Employment Laws, Part 1. Most of you on the line today are Vigilant members. For those of you that aren't, a quick introduction. Vigilant Law Group works with West Coast production and manufacturing companies on complex HR law issues. We have attorneys licensed in Oregon, Washington, California, Idaho, and Montana. And you get two of those attorneys today. My name's Jodi Slavik. I'm an employment attorney licensed in Washington. Helping me behind the scenes is Chris Edison. He is licensed in Oregon and Washington. He will be monitoring the Q&A box today. So as we move through this content, please post your questions in the Q&A box. He will be answering them as we move along. Some of them he'll pull aside to ask me at the end of the webinar today. A few administrative items before I dig in. First of all, a PDF version of the slide deck was attached as a link to the reminder email you received this morning and is available in the chat box as well. The PDF won't have active hyperlinks, but it does have website addresses for you to use. As I just mentioned, please use the Q&A button on the bottom of your screen to ask questions. Next week or so, but very soon, we will send a link to this recording. And perhaps it goes without saying, but these laws are brand spanking new. So a lot of the state rules and guidance documents have not been released yet. Watch the newsletter for updates on when the state rules and guidance are released, as well as the date for part 2 of this webinar. Why a part 2, you ask? Well, the legislature was so busy this year and passed so many laws that affect employers that we decided to break them into two groups. The laws that we are going to talk about today take effect this month, July of 2025. The laws that we will talk about in October take effect on January 1st, 2026 and after. So during the registration process, I know a lot of you asked questions about background checks and changes to Washington paid family and medical leave, lactation, and postpartum pregnancy accommodations. And I know several of you asked questions about unemployment insurance for striking workers. Well, for those laws and a few others, I'm not going to talk about those laws or answer questions about those today. Stay tuned for part 2, and we will let you know when part 2 is coming in the Vigilant newsletter. Today, what I'm going to cover are business closing or layoff, mass layoff notification requirements, changes to employee personnel files, job postings, driver's license discrimination, and a grab bag of other issues like laws about coercion, sick leave expansion, collective bargaining for cannabis workers, and payroll records for prevailing wage. We are going to kick this off with a probably the Mac Daddy of of laws that was passed this session because I wanted to cover this information with you while you were still fresh. So this law is in gross substitute Senate Bill 5525, business closing or layoff notification. The subject can be, frankly, a little depressing. So hopefully most of you won't have closings or layoffs, but if you do, you need to know the laws that apply and what to do. Okay, so let's talk about those laws. In 1989, Congress passed the Worker Adjustment and Retraining Notification Act, otherwise catchily and appropriately called the WARN Act. It requires employers with 100 or more full-time employees to warn employees, unions, and government entities at least 60 days before mass layoffs or plant closings happen. Washington passed its own version this year that goes into effect on July 27th. Um, while most people have been referring to this new Washington law as the Mini Warren Act, it in fact does have a name given to it by the legislature, a really bad name with a really bad acronym. It's called the Washington Securing Timely Notification and Benefits for Laid Off Employees Act. Wisdom blowy? Wisdom blowa? Okay. So, for purposes of today, I'm going to call it the Washington Act or WA. Washington's Act is very similar to the Warren Act, but there are some key differences you need to be aware of. The first being that it applies to smaller employers. One of the first questions employers usually have when there is a competing state and federal law on the same subject is, well, which one do I have to follow? If you have under 50 full-time employees, probably neither. If you have between 50 to 99 full-time employees, probably just Washington. If you have 100 or more employees, you'll apply both. When there's a conflict, you'll apply whichever provision is more employee friendly. Okay. So I'm going to do a high-level flyover of the Warren and Washington process, highlighting some of the key differences. However, these laws are complicated. They have a lot of definitions. They have a lot of exceptions or exclusions. And I don't have time to cover them today. And frankly, it's just too much information. I will say again that this is an area where you absolutely want to engage with your Vigilant Law Group attorney or company attorney as soon as possible when you know a business closing or layoff may happen. Okay, so this slide helps you see the key provisions of both laws and where they're same and where they're different. Everything in the new Washington law is in these orangish, salmonish boxes. We'll call them orange today. Orange boxes indicated by Washington, or where both the Washington and Warren laws are the same, it will say both. If it's a Warren only requirement, it will be in a gray box and say Warren. Okay. So let's say you get wind of a potential closure or downsizing in your business. First, you want to figure out, am I a covered employer under the law? To do so, you count your full-time employees. For Washington, it's 50 or more. Under Warren, it's 100 or more. For both, you leave out part-time employees, which is defined down here. And conveniently, it's the same part-time employees, the same for both laws, although Washington has one little difference if you have a union contract. So if you determine that you're a covered employer, then you move on to see, well, is this a closing or is this a mass layoff? For both laws, closing is a permanent or temporary shutdown that results in employment loss for 50 or more employees during any 30-day period. Employment loss is defined down here, and it is the same for both laws. One difference, however, is that Warren has a 90-day look back and look forward period. If you don't hit that 50 plus employment loss in 30 days, look back and forward to see if you will have an aggregate related loss that hits that level. Washington doesn't have the same requirement. If you're not experiencing a closing, then you're looking at the mass layoff definition. And this is an area where Washington and the Warren Act are fairly different. Under Washington, a mass layoff is a reduction in force or RIF um, that causes employment loss during any 30-day period for at least 50 employees. Importantly, Washington tucked in this provision that says, oh, you can't include anyone taking Washington paid family medical leave in a layoff. Okay. There are some exceptions. But this is one of those areas you need to talk to your attorney before you include anyone who's taking this type of leave in the layoff. So Warren is a little bit more detailed. Here, the RIF has to impact at least 33% and 50 employees, or if it's so large, the 500 employees, for it to be a mass layoff. And this is also an area where Warren has the look back 90 days and look forward 90 days for these numbers. So again, it has this 33% and 50 at a single site, whereas Washington just says 50 anywhere, okay? Anywhere in the state. If you determine that Washington or Warren applies, you need to send notice no less than 60 days before the employment loss. If you don't initially send notice because it's expected to be a shorter layoff, you may need to send notice later if a layoff is extended. And the difference between the laws is the length of layoff. 3 months in Washington, 6 under Warren. And in both situations, then the notice must be sent as soon as the extension is known. A notice will be going to the union, if there is one, or to each affected employee. And this is the first time part-time employees are included. You need to send notice to them as well as the state dislocated workers units. So, and for us, that's the Employment Security Department. Warren also requires notice to the chief elected officer of your local government where the closing or layoff will occur. The notice, for the most part, for both laws, the base information is the same. Washington does have some notice add-ons included. There are a few possible reasons that excuse you from sending notice, including faltering business, although for Warren, this is only for plant closings, unforeseeable business circumstances, natural disaster, and in Washington, certain construction projects for mass layoffs only. Notice I emphasize possible. This is an area where you need to talk to counsel before you make a decision that, no, notice isn't required for us because this was a natural disaster, for example. There's a lot of details going on in these laws behind the scenes. Okay, so let's move on to liability. A question you may get from leadership, especially if you suddenly get word from the president that this closing or layoff needs to happen in 30 days, is, well, what's our exposure? What's our liability here? Under both laws, you can be sued by the affected employees for back pay and benefits, including medical expenses they had for the amount of notice time that you missed. So if you sent notice 30 days before instead of 60, you'd have exposure for 30 days only, not the entire 60-day period. If they're successful in suing you, they have the ability to get their attorney's fees. And for some icing on the cake, you can also be subject to civil penalties. Although Washington did add a provision saying, hey, if you have to pay federal civil penalties, that's good enough. You don't have to pay state penalties as well. Okay, so here are our tips if you are potentially facing a closing or layoff. First, as soon as you hear that a downsizing or layoff may happen, count your employees and probable employment losses. to help to start the process of determining will these laws apply. And don't forget about each law's unique requirements. I included a couple in this checkbox. For example, in Washington, are layoffs occurring across the state at multiple locations? Under Warren, did you consider that 90-day window? Now, because doing these things are fairly complicated, perhaps call should have been first, but definitely call your Vigilant Law Group attorney or company attorney to review these requirements and whether you have obligations under one or both laws. And finally, remember that communication here is really two ends. The first end is communicating to your leadership about responsibilities, timelines, and potential liabilities so they can make their best planning decisions in what is a fairly stressful time. Um, and then also the communication on the back end where you're sending notices to employees, union if there is one, etc., so they can prepare for the impact on the back end. Here are your resources for you to use. If you're a Vigilant member, you have access to all of these Warren-related legal guides on the member website. There are actually far more than these on the member website, but these are the legal guides that I initially recommend that you consult. All of these are in the process of being updated to include the Washington provisions, but the Warren information in those legal guides is current. For all of you, these are other resources to consider. The Department of Labor Warren site, which is current, as well as the Employment Security Department, their landing page on layoffs, as well as rulemaking that they will be conducting on this. So these are not updated yet, but presumably they will be. Okay, leaving closing and layoff behind, and then let's move on to Employee Personnel Files, Substitute House Bill 1308. So a good way to review this law is with a scenario. Ruben is 56 and works in packaging. No one really likes working with him because he's sarcastic, refuses to help others, and yells when he's angry. Ruben also calls out sick a lot on Fridays and Mondays. After a string of unexcused absences, you decide to terminate. At the meeting, you keep it simple and say, Ruben, it's time for us to go separate ways. Ruben isn't happy, but he doesn't complain. 2 days later, you get a long ranting email from Ruben saying, well, you just fired me because I was the only man working in a hostile group of cranky women that always ganged up on me. He demands a reason for his termination. The question is, do you have to give him one? Yes. Yes, you do. So current law says that you must give Ruben a written statement with the date of and reasons for his termination within 10 days of getting Ruben's email. The law taking effect on July 27th modifies this requirement slightly. You will now get 21 calendar days to respond with the date of termination, whether there was a reason, and if so, what reasons. Another key difference is that Ruben doesn't need to ask for this. His attorney or designee can. So in your response, you don't need to, nor should you, go into a great amount of detail about the reasons for the termination. If he was terminated for multiple policy violations, like in this situation, it's sufficient to simply say that. However, it is best to talk to your Vigilant Law Group attorney or company attorney if anything looks like it is on train tracks towards a potential claim or litigation. Wait, there's more. So it's been 3 months since Ruben was fired. You get an email from Ruben's out-of-state attorney asking for his personnel and payroll files. It includes a release signed by Ruben. You're worried that Ruben's attorney is looking for reasons to sue you. Do you have to send the files? Under current law, no. No, you don't. As of July 27th of this month, yes. Yes, you do. Let's do a side by side so you can fully see what's changing. Right now, employees have the right to view their records at least one time a year. L&I says employees includes former employees in its guidance. On July 27th, the list of who can request files once a year is expanded to employees, former employees, and their designees. So former employees are only those who have separated within the last 3 years of the request date. Designees are most likely going to be attorneys for the employees or former employees. Currently, when you get a request like Ruben's, I have recommended to my companies that I work with, like, just respond, say, Ruben, we'd be happy for you to come on site and look at the files. Please let me know a time you'd like to come on site. And this prevents a lot of legal fishing expeditions because most employees don't want to come on site, nor do their attorneys. However, in a big win for employees and trial attorneys, the new law requires employers to send a copy of the personnel file at no cost to the employee or their designee. So existing law and regulations don't dictate what must be in personnel files, but L&I in guidance has said, hey, consider putting all of these things in your personnel files. The new law is very specific about what must be included in personnel files. That includes job application records, performance evaluations, non-active or closed disciplinary records, leave and accommodation records, payroll records, and employment agreements. Now, notice I added on the slide if you have them. So let's say you don't have performance evaluations for this employee. You don't have to create them. You also don't have to start doing performance evaluations if that's not your company practice, just because the law says to put them in the personnel files. The law just says if you have them, they must be in there. Also notice that I have payroll records italicized. This is a pretty big change because payroll records have their own laws and regulations in Washington about what needs to be in those files and when you have to deliver them upon request. So if you currently have those files separate from your personnel files, keep them separate. We're not recommending that you merge the files. You simply need to be prepared to include a copy of them when you send the personnel file because of a request. Finally, current law doesn't give enforcement teeth, but the new law does. So people requesting files that don't receive them, so long as they give you notice of their right to sue and 5 days, then they get to sue you for equitable relief, damages, and attorney's fees. So this is a good reminder. Don't ignore those requests when they come in. Our personnel file tips. First of all, review your personnel and payroll files, if not now, and it doesn't necessarily have to be a comprehensive review, but certainly before you send the file. There is a specific legal guide for Vigilant members that is great for you to use to figure out what should be in the file and what should not be in the file. Next, as I just mentioned, continue to keep the personnel and payroll files separate. Just be prepared to include the payroll records. I'm recommending that you create an internal HR records request checklist, including who responds, by when, and what files are included. This will make responding to a request faster and safer, especially if you have any turnover in your HR team. Another action item is to create an expectation or double down on the expectation that supervisors keep accommodation records, meaning what accommodation did we provide, when, what changes did we make. So I love doubling. Not only is this new law saying if you have those records, have them in the file, it's really important to defend yourself against a discrimination claim to have those types of accommodation records. Finally, call your Vigilant Law Group attorney or company attorney, particularly if you think a claim or lawsuit may happen. Here are your resources to use. Uh, Importantly and wonderfully, Vigilance Legal Guide, Personnel Files and Access to Records is hot off the presses and updated for you to use. This is the resource I recommend for you to use as a checklist to cover exactly what should be in your personnel files and not in your personnel files. Our payroll record checklist is in the process of being updated. For all of you, meaning the including the non-vigilant members, you have access to the L&I payroll and personnel records landing site, as well as two really helpful detailed administrative policies listed or provided here. However, the website and the administrative policies have not been updated yet. So keep that in mind if you're using them in the near future. We will let you know when they are updated and released by L&I. Okay, let's move on to Substitute Senate Bill 5408, which makes changes to Washington's pay transparency law. So for those of you saying, didn't we just have changes on equal pay and job postings? Yes, yes, we did. In fact, if not all, every year, if not every year, almost every year for the last 5 or 6 years, the Washington State Legislature has been tinkering with the Equal Pay and Opportunities Act. So one of those changes was pay transparency in job postings that took effect on January 1st of 2023. Because the new law makes changes to that law, I'm going to give you a quick refresher on what that law is about. So currently, employers with 15 or more employees must disclose reasonable and genuinely expected wage scale or salary range and a general description of other compensation in job postings intended to recruit job applicants for specific available positions, including qualifications. So this excludes the help wanted or we're hiring now ads. This information must also be provided to employees that are offered internal transfers or promotions if they ask for it. Okay, so with that refresher, here's what's new. First, a fixed wage amount is allowed instead of a wage scale or salary range, and this is both for job postings and internal transfers. And I know there's several of you out there going, that's what we said. Because when this new law rolled out and we were introducing it to the companies we work with, the companies were saying, but we don't have a scale or a salary range. And the best we could say is, well, the law says you have to have a range or scale. Well, no longer. Now, if there's just a genuine fixed wage amount, that's all you have to include. The next change gets a little bit more to liability exposure, which is also what these last two provisions are about. This is because after this law took effect in 2023, we saw a whole bunch of class action lawsuits filed because attorneys quickly figured out that their clients or applicants could file a claim for $5,000 in damages for job postings that didn't comply with the law. And then if you add that up for a job posting that includes a lot of applicants for one company, that's a lot of potential money on the line. So the changes now, first of all, to reduce the scope of liability, the new law says a job posting is not a solicitation that is digitally replicated and published without the employer's consent. So you may contract directly with a third-party poster, but if somebody else is pulling that posting and putting it on their website or aggregating it, you're not liable for that extent of the posting. And these last two provisions, the opportunity to correct and the new enforcement provisions, let's talk about here. So, for a 2-year period, for the next 2 years, if anyone has a beef with your posting, they have to give you written notice of the problem. And you get 5 days to fix it, which includes contacting your third-party posting sites with a demand to correct the posting. Recognizing the legislature saying, okay, so the third party may not be able to, that process may not happen for the change to occur within that 5-day period. But as long as you have proof that you reached out to the third party poster saying you must change our posting to say this instead, that will be sufficient. If you don't correct, then the complaining party can choose a path. Either administrative action, which is L&I investigating and potentially issuing citations, or a private lawsuit. And in this case, the complaining party would have to do so within 3 years. Here are our job posting tips. First of all, perhaps not surprisingly, review your job postings. Some of you still haven't updated your job postings consistent with the law that passed in 2023. So, great opportunity to go back and do so now. Make sure you have the wage scale or salary range or the fixed wage, if that's the case, as well as the list of benefits. Remember that a written notice of deficiency, meaning your job posting is inaccurate, can actually come from anyone. It doesn't have to come from an applicant. And once you get notice, it serves as notice for everyone for the duration of that posting. Retain the date and content of any deficiency notice that you get in, the changes you made to the job posting, and the written communication you made to third parties about changing your posting. You need to be able to prove I responded and I followed the law to be able to avoid liability. And as always, phone a friend if you have any questions about that. Here are your resources to use. Not only is Vigilant's legal guide, Equal Pay, Avoid the Pitfalls, updated, but we are also making this resource available to all of you, members and non-members alike, on this webinar today. So for members, go to the member website. For non-members, use the landing page provided here. So this is a phenomenal legal guide because it thoroughly reviews federal and state equal pay laws in Arizona, California, Oregon, Washington, Idaho, and Montana. It talks about common mistakes employers make in this area, how to avoid or fix those mistakes moving forward. I have included a few L&I resources, including a fact sheet and administrative policy They have not been updated yet, so my advice remains the same. Be careful if you're using the resources now and watch our newsletter for when we announce that the resources have been updated. Okay, deep breath. Moving on to substitute Senate Bill 5501, driver's license discrimination. Starting on July 27th, this new law says employers can't require a valid driver's license as a condition of employment or include a statement in a job posting that an applicant must have a valid driver's license, unless driving is one of the essential job functions or related to a legitimate business purpose. Now, a lot of you have asked, well, what's an essential job function? Or how do I know it's a legitimate business purpose? Unfortunately, the law does not define those terms, and the state has not released rulemaking on what this exactly means or what their expectations are. In the meantime, we think this means that driving and the type of driving that actually would require a driver's license, not being on a riding lawnmower or a forklift, for example, that licensed driving is one of the core necessary aspects of the job or serves a genuine business need. Let's look at some examples. So I pulled these postings off the web, off the internet. The Parks Interpretive Specialist 1, as you see what's highlighted here, it does require a valid unrestricted driver's license. Driving may be essential to this job, and we don't know all the details in this posting, but the core function looks like it's developing and delivering interpretive programs such as guided walks, talks, presentations, and junior ranger programs. There's nothing about driving individuals anywhere in this. So if a core duty was driving people on tours, then it would be an essential function. Or if the Parks Department had a genuine need for tour guides to have licensing because of their own legal requirements, like the law requires all of their employees to have a license for another reason, or all of their employees are expected to drive at any one time, then that could be related to a legitimate public purpose. Excuse me. So then looking at this posting for roofing and insulation assistant, there's two positions opened at $20 an hour. So very likely this is an entry-level roofing assistant position. So if the roofing assistant actually needs to drive the roofing truck as part of their job duties and core job duties, like they're the person assigned to drive everyone to the job sites, then yes, you can require a driver's license. However, I'm guessing that entry-level assistants aren't all assigned a truck or aren't all expected to drive regularly. Usually when you see this requirement, it's either because companies, well, we've always required a driver's license, so it's just always populated and repopulated in the job posting. Or companies will say, well, I like to require a driver's license so I know that they'll show up on time. I know they're reliable, or some other reason like that. That's what the law is trying to get to. Because if you're requiring a driver's license when it's not a genuine responsibility or need of the job, you could be keeping qualified people from applying. You could have disabled individuals that don't have a driver's license but are qualified to do the job. There's a lot of young people these days that aren't getting driver's licenses either. One thing I want to point out in this posting that gave me a little case of legal hives was this requirement: all candidates must be physically healthy. So it is okay to ask for, if it's a genuine need, climbing ladders, lifting more than 50 pounds, working outside, because that's specific to the job duties. A very generally, hey, you have to be physically healthy to apply, invites a discrimination claim. Here's an example of a job posting where driving is an essential function and related to a legitimate business purpose. Um, I don't know about you, but I had to laugh when I pulled this posting because I've never seen parking enforcement officers look this happy about their job ever. So maybe it's fabulous to be working for the city of Seattle. Mistakenly including a driver's license requirement when it's not an essential function can lead to an L&I investigation with damages, costs, and penalties assessed. Here are our driver's license tips. Review your job postings, and if you require a driver's license, consider whether it's actually an essential function or related to a legitimate business interest. Like if this employee is delivering products in the company vehicle as a key duty. If you want someone who can reliably show up to various job sites, then ask for that. Don't assume that they need a car to do so. And as always, phone your attorney friend, your Vigilant Law Group attorney or company attorney with any questions, particularly if you're unsure of whether you can ask for a driver's license. Here are the resources that I recommend for Vigilant members. The Vigilant Legal Guide Washington Laws That Affect Employment. This is an extremely comprehensive and extremely helpful compilation of all Washington laws that affect employment. However, it is in the process of being updated to include the new laws that I'm talking about today. Other resources are the fact sheet and administrative policy produced by L&I, not updated yet, but we expect they will be. Okay, so let's move on to our final four: coercion, paid sick leave expansion, collective bargaining for cannabis workers, and payroll records to check on prevailing wage. A little background or reminder, perhaps, is that in 2020, Washington amended its law against discrimination to protect citizenship and immigration status. This means that employers can't use a worker's national origin, immigration status, or citizenship status in making employment decisions, like hiring, promoting, and discipline. So the law that passed this year, Senate Bill 5104, adds to this by saying employers can't coerce, which in this bill means to threaten, compel, or induce an employee to take or not take a legally protected action involving wages, labor standards, and safety. Example would be telling an employee to lie about how many hours they worked that day, or warning an employee not to file a complaint with L&I. So threats can be obvious and direct, or subtle communication about an employee's or their family's immigration status. So an example of this would be, you better not make too much of a scene about how hot it is out here or, limited water. I heard ice was in the area, and in fact, in your neighborhood. And I know you've been a little concerned about your family. I wouldn't want anything to happen. Enforcement for this law is as follows. A coerced worker can file a complaint with L&I. within 180 days of the event happening. L&I will investigate, and either it'll say, we can't substantiate, we can't find enough facts to show this happened, or if they find a violation, it'll be 1,000 for the first, 5,000 for the second, and 10,000 for any subsequent violation. Continuing on our theme of immigration, our next bill is Substitute House Bill 1875. Taking effect on July 27th, this bill expands Washington paid sick leave to allow the use of accrued leave for immigration proceedings. So the paid sick leave right now, the paid sick leave law right now allows you to ask for verification after the third day for a sick leave use. This law also allows you to ask for verification, which would be getting documentation from an advocate, attorney, clergy, or other professional. Or the employee's own written statement will suffice as well. So similar to the paid sick leave law, uh, it's it's been written to make it very easy for the employee to verify their need for that absence. Okay, so what does this mean? Your favorite. It's time to update your paid sick leave policy. Uh, Wonderfully, our model paid sick leave policy is updated with this information and ready for you to download from the member website if you are a Vigilant member. For those of you that don't have access to the Vigilant member website, the Department of Labor and Industries does have a paid sick leave policy employer resource center. This is the landing page for it. It's not updated with the new law, nor does it have an updated model policy yet. However, I don't know, it was a week and a half ago, maybe week and a half ago, sent out notice that it's doing expedited rulemaking on this subject, and it expects to have rules about this on September 3rd, which indicates that a model policy will be available then or shortly thereafter. Okay, the last two bills. First, engrossed substitute House Bill 1141 establishes collective bargaining rights for cannabis workers. So, although workers in the private sector already have the right to organize under the National Labor Relations Act, agricultural laborers are excluded. So this bill doesn't tackle the entire issue of agricultural laborers. It zeroes in on cannabis workers who cultivate, grow, harvest, and produce cannabis on a farm. So those organizing rights and protections have oversight in the state by the Public Employment Relations Commission, which is known as PERC. Why the Public Employees Relations Commission? I don't know. Interestingly, PERC also has oversight over one other private sector group, and that is symphony musicians. So, roll that out at the next party you go to. The next bill is House Bill 1821. And this is for those of you that have public works contracts. Those of you that do know that there is a group of interested parties that can request your payroll records so they can confirm that you're actually paying prevailing wage. What this bill does is it adds the Joint Labor Management Cooperation Committees and Taft-Hartley Trust to the list of interested parties that can ask you for payroll records. I don't know this area well enough to know why this change happened. I do know there was a little bit of a dust up behind the scenes, and an amendment was added to say, hey, if the Joint Labor Management Cooperation Committee asks for this payroll records, that information can only be used for prevailing wage complaints, not other matters. Both of these laws take effect on July 27th. Okay. Woo, that was a lot of information. So, Chris, how about I hand it over to you, and let's tackle a few questions that came up during the Q&A.
Yeah, sure. So, the first question for personnel records, does the law state how the records must be sent via email or regular mail?
Ah, good question. No, it does not. It simply says that a copy, which is not defined yet, has to be sent at no cost. So, Um, given the current technology age, and some of these requests you're getting out of state, I would be really surprised when L&I comes out with rulemaking or guidance on this. I would be very surprised if they say you can't send via email. I think it's safe for now to send via email so long as, again, there's no cost, meaning you're not saying, hey, it's going to cost you this much to download, and you confirm that it is, it's a file that can be received and opened by the party on the other end.
Thank you for that.
You're welcome.
Next question. Can we require a person to give us who their designee is in writing before releasing personnel records?
Oh. Uh, Okay, another good question, and another area that we don't know for sure yet because the state hasn't released rules or guidance on this, and the law doesn't specifically address whether you can require that in writing. It doesn't say you can't require it in writing, and I think it makes really good sense for you to require some statement of confirmation. I think attorneys will still send, hey, here's a release signed from my employee. But anytime you get a designee that says, oh, I'm the designee, I'm the employee wants me to send this file, I think it's appropriate to contact the employee and say, uh, can you just give me written confirmation that this is your designee so someone doesn't make a privacy claim or have a concern along those lines down the road? And of course, if we hear something different from L&I when the rules are out, we'll let you know.
So moving forward to the driver license requirements, if our employees may have to drive to pick up supplies or drop off other workers, is that a legitimate business purpose?
So if the employees have to drive, you said to pick up supplies or drop off other workers?
Correct.
Well, I think it depends. Here it is again. We don't know for sure yet, because the state hasn't, the law didn't identify, and the state hasn't released guidance yet on particularly the legitimate business purpose. I think the essential job function is easier for understand that this is a core necessary function related to a legitimate business interest is a little vague. And we're all like, well, anything could be related. So where is L&I, or where is the state going to draw that line? I think right now, if the employee is reasonably expected to be picking up supplies and dropping off employees, then that might even rise to the level of an essential job function. If it's only occasional, I would be prepared to show that this is a genuine need. We don't have other individuals can do this, and this is what we need for us to get this part of our business done. So it's kind of going through the mechanics of what would you say if someone asked you if this is a legitimate business purpose? Um, this is a great question. If you have a very specific job or a specific posting, to talk to your Vigilant Law Group attorney or your company attorney to say, what do you think? Can I include a driver's license requirement given these are the duties that we're including? Good question.
Looks like we have time for one more question. So, if Washington Warren applies to a RIF or a layoff, just confirming that we must give job titles and names of employees to everyone that is a part of the RIF or layoff.
Yes. So in a RIF or layoff and you've determined that notice is required, then yes, if there is no union. So if there's a union, you're providing names and job titles only to the bargaining representative who will in turn give notice to the employees. If to the employees, then yes, you need to include names and job titles included for that situation. Okay, so Chris, you said that was it?
Yes, thank you, Jody.
Yeah. Okay, so given that, I know Chris was answering some of your questions as we move through the content. If for some reason we didn't capture your question there or capture your question here at the end, please contact your Vigilant Law Group attorney or company attorney with questions. Several of you on today are interested in SHRM or Washington State CLE credits. Here is your information. I think the key information you need to know are the activity ID numbers. I'm going to pop off this slide, but remember that these numbers are included in that PDF that you received. And uh, don't forget that you'll receive a copy of this recording in your inbox very soon. We expect in the next week. For those of you that aren't members and are interested in membership, please check us out at www.vigilant.org. To all of you, thank you very much for your time today, and I look forward to seeing you for part 2 of this webinar in October.